Numbers 10 and 11, Hummel versus Aiden Kearney, 23 CR 313, 24 CR 43. Let me just update this. Mr. Kearney is present and represented by attorneys Timothy Bradle and Mark Federer. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for hearing on the defendant's motions to dismiss. If the parties could please identify themselves for the record.
Morning, Your Honor. Robert Cosgrove for the Commonwealth. I guess it's a late morning. I should have said good afternoon.
Hello, Your Honor. Timothy Bradle on behalf of Aiden Kearney. He's here in my, to my left. And Mark Federer, Mr. Kearney.
Hi, Mr. Federer. Good afternoon. Okay, so I got the motion and I got the response. Why don't I do this? I've got some questions, and then I'll throw out at the beginning, maybe both sides can answer them. Why don't I start with the defense and then I'll go to
Sure.
Mr. Cosgrove. So, Mr. Kearney certainly a journalist. He's a satirist. Mr. Bradle, where's the line? How far can he go to satirize things? And when does it become a crime? I asked that to Mr. Cosgrove as well to address. How does the conspiracy counts, which are 14, 15, and 16, how do they fit into this? How is that intimidation?
Mm-hmm.
Are there people that are mentioned in these indictments who are non-witnesses, specifically as to counts 5 and 15? Tell me, Mr. Bradle, where you think that the motorcade, how does that fit into this? Where is the intimidation there, Mr. Cosgrove? You can obviously speak to that, but Mr. Bradle, I'll start with you.
Thank you, Your Honor. You know, as usual, Judge, you cut right to the point. I appreciate that. You know, we have about 75 pages between counsel and I, and I'm happy to answer those questions. The first, the where do you draw the line thing, Judge?
Yeah, where do you draw the line?
Sure.
So he's a journalist. He's got his blog. He's got the website. I'm sure he gets a lot of activity, and he's covering a case. So he's acting as a journalist. But how far can he go?
Sure.
You know, and I say this to Mr. Cosgrove maybe as well. How about Michael Moore or somebody like that, or somebody who's a satirist in some way? I was trying to bring attention to a certain thing. How far does the First Amendment go in their protections? Go right ahead, Mr. Bradle.
Thank you very much, Your Honor. Judge, it is actually a clear line. It's O'Brien v. Borowski. Okay, Judge, I know you're all over this. O'Brien says that all of these strictures that talk about speech and distress and everything else, it's limited to true threats and fighting words. O'Brien says that. Watts in the Supreme Court says that. This is just well-settled law. It's unquestionable. So it has to be true threats or fighting words when the issue is speech. And that's what we have here, we contend, is this is just Mr. Kearney's speech.
How about if he says words to the effect I'm going to ruin your life? Is that enough?
No, it's not enough because it's not a specific threat in terms of any criminal behavior. And that actually is specifically addressed in O'Brien, and it's Snyder v. Phelps, Judge, Snyder v. Phelps. That's the Westboro Baptist Church case where they picketed a dead soldier's funeral. I mean, the most repugnant stuff you can imagine, but it's inflicting emotional distress in public on a matter of public concern is protected. So, and O'Brien specifically talks about that the fear needs to be defined. It's fear of property damage or being a victim of a crime. It's not fear of being sued. It's not fear of being embarrassed. It's not Ms. McCabe in Stoughton District Court saying, is there any way you can get him to stop blogging about me, Judge Walsh? That's not the fear we're talking about.
How about calling it phony pizza riders at a pizza restaurant?
You know, I'm glad you brought that up too. There's no evidence whatsoever, and he did do that. Mr. Kearney did not tell people to do anything with respect to that, but more to the point of our motion here today, there's no evidence of that. You know, I don't want to sound sneaky when when I say, oh, there's no evidence of that. He didn't do it, A, and B, there's no evidence of it. And that's what we're here for, is to look at the evidence in the grand jury. There's no evidence whatsoever that he told anybody to inflict economic harm on the guy. Even if he did, which he didn't, how is that a crime? It might be something he could be civilly sued for, but it's not a crime. But the most important point on that, Judge, is that he didn't do it, and there's no evidence of it. That points up something that we want to address as well, Your Honor, is the idea that there's so much imputed derivative liability infecting these grand jury minutes. It's ridiculous. You know, it's as if the Commonwealth just basically forgot about the notion of joint venture and just wanted to attribute every bad thing that has happened to any one of these complainants to Mr. Carney. I'll give you a ton of examples. Proctor says people drove by and spit on my lawn or whatever. That's got nothing to do with Mr. Carney. They have no evidence. He said, hey, let's get into joint venture here for you to drive by and spit on his lawn. It's got nothing to do with Mr. Carney. Another example that should throw out the entire case is McCabe. Jennifer McCabe says, I got an email that someone was going to rape me on my front lawn. That has nothing to do with Mr. Carney. The fact that there are other people, many of whom are in this room supporting the First Amendment and supporting Mr. Carney, that are concerned about this and that speak out, Mr. Carney is not responsible if they cross some line. It's not his cross to bear, Your Honor. If the government wants to make a joint venture case, let them try, but they certainly haven't here. And that's the most important point, is that all of these derivative liability things, you got to throw those out the window, Your Honor. You can't use them as a basis to uphold an indictment, but also there's no evidence of it. There's no evidence that he did anything wrong. So all those derivative liability things, Judge, I hope that, you know, I know you've looked at everything. When you look at it again, it can't apply to Mr. Carney. It's just not within the law. It's not even, you know, Zanetti, defense lawyers talk about Zanetti all the time, about how broad it's become. It doesn't even come in the galaxy of Zanetti. There's no evidence that Mr. Carney urged anybody to call the pizza man and, you know, order things and not show up. There's no evidence about the Proctor thing. He's got nothing to do with the Jennifer McCabe emails. All these things, Judge, are the government's attempt to just throw enough mud at him so that a judge who's swamped with these things says, there's all these allegations. I know you're not going to do that, and that's why we're here in front of you, is because we have every bit of faith that you're going to look at this in the way that it needs to be looked at, and that you're going to look at it on the right side of the First Amendment, Your Honor. The derivative liability stuff's got to be out the window.
Okay.
Can you refresh my memory on your next question, Your Honor?
I think I had asked a couple of questions, one of which was, where is the line, the conspiracy, which I think you talked about,
Yes.
and then the motorcade, which you talked about as well. How about the one with people who, in counts 5 and 15, who are at least, it's the same person, but are, it's intimidation of a witness. Is that person a witness?
I just don't have it in front of me, Judge, in terms of 5 and 15 is the allegation. Elizabeth Proctor, yes, she's not a witness, but the breadth of the witness intimidation statute, Judge, does cover family members of a witness.
Okay.
So I'm not taking issue with that, but it just goes through every single one of these. It doesn't rise to the level of threats or fighting words, Your Honor.
Okay.
It's just, you know, and the other huge issue that the Commonwealth ignores and just wants to look the other way and go after somebody out of their own self-interest, and we'll get to that later, but is this notion that political hyperbole is somehow off the table. So I'm going to rewind a little bit, and that's the Watts case. It goes back to 1969, Your Honor, when a guy who was speaking about the draft, and he said that if they put a rifle in my hands, the first person I'm going to get in my sights is the president, LBJ, Lyndon Baines Johnson. And he was prosecuted under the federal threat statute. And the Supreme Court, you know, they laid it out very clearly. This is called political hyperbole. The context, the distance, the First Amendment aspects of it, it's political hyperbole. It's not really going to happen. It's It's something that a First Amendment protected speaker says to underline their point, to underscore the force, the rhetorical force of what they're saying. So that principle, Your Honor, is sort of the foundation for a lot of the case law that I cite in the brief, that we cite in the brief, and that, you know, it's.
So words to the effect of, I'm gonna destroy someone's life, or I'm not gonna let them lead a comfortable life.
Right,
That's what your argument is, that
exactly.
even under that case law, which is obviously a little bit different, but yeah.
Controlling, Your Honor.
That's,
I think the word you're looking for.
yeah, well, that might be your word, but I'm saying
You know, it's the Supreme Court, and that's another issue we want to talk about, judges. You know, the Commonwealth of Massachusetts just forges ahead with this ridiculous statute, this witness intimidation statute. If that statute was passed in 1775, every single one of those legislators would have been pulled out of the State House and tarred and feathered on Boston Common. That statute is ridiculous, Your Honor. It talks about inflicting economic harm, inflicting emotional harm. I think someone's going to receive emotional harm if they hear speech that says, "You're a liar, I'm going to sue you." Under the statute, that's a felony in Massachusetts, not in the rest of the world, not in the rest of the country anyway, not under the Federal Bill of Rights and the First Amendment, but apparently in Massachusetts and in Norfolk County, it is.
Okay, let me turn to Mr. Cosgrove. Let's give answer to that question.
Thank you.
Let me turn to Mr. Cosgrove. Mr. Cosgrove, maybe, so some of these counts, I mean, there's obviously a lot of counts. There's 16 of them. But going to count 8, which involved a member of the state police, where he's walking out of the courthouse here and allegedly the defendant directs the attention of certain people towards him. And then they chant and they call him names. Does that rise to the level of intimidation of a witness?
I think that's probably the one closest to the line, Your Honor,
Okay.
candidly. But if you look at the testimony and if you view the video, you'll see that he's pursued down the street, he's shouted, he's approached by people accompanying Mr. Kearney with cards that they're waving and so forth. And I certainly think he could have legitimately feared for his safety. The fact that he's a rather robust gentleman and there are other police officers around might mitigate that fear, but I don't think it was totally unfounded.
Okay, well, but some of my other questions, that just, you know, as we get into these specific indictments, as to the indictments that are at the end of the 14, 15, and 16, that talk about the conspiracy with the person who evidently worked for the police department to get license plates and puts them out there. What's your theory on how that amounts to intimidation of the witness?
A conspiracy to intimidate a witness?
Yeah,
Which is a little different, as Your Honor knows, from the actual intimidation.
yeah.
There was testimony that this person had done this sort of thing for Mr. Kearney before, that she was familiar with his online activities, and that she knew that what was likely going to happen when she turned over this license plate was that it was going to be used to dox the witness. So I think that's the essential theory. And there was also a suggestion, as I recall it, that she herself had had some interaction with Mr. Kearney in the past in connection with a niece or something like that, and didn't want to get on his bad side. And I would suggest there was a reason that she didn't want to get on his bad side.
Okay. As to some of the counts that go into the motorcade, where it goes to different people's houses with a motorcade of followers, the actions of Mr. Kearney, are you suggesting that he's acting as an individual or he's acting in some sort of joint venture?
Well, I think the evidence would certainly support joint venture. Essentially, there was evidence that Mr. Kearney planned this motorcade, that he broadcast what the location, the gathering point was going to be, that he showed up with a bullhorn to address the crowd, that he had his cameraman, or perhaps it was he himself with his phone to film the events for later broadcast, that these people proceeded at his direction to the various locations. Only the first location was announced in advance. So they got there by following him. And when he got there, he got out of the car, and statements varied somewhat from location to location, but harangued the occupants of the house as to.
So let me ask you about count two. So count two talks about intimidation of a witness, 25 to 30 people. Mr. Kenny with a bullhorn telling a witness to tell the truth. How is that not free speech?
Well,
So what involves name? This count,
it's the one that involves what?
Ms. Name, count two.
Well, I don't want to sound like Bill Clinton. It depends on what the meaning of is.
All right.
But
I mean,
in the context of Mr. Kearney saying, tell the truth, I think the witness would clearly understand that what he's instructing the witness is tell my version of the truth.
okay. All right.
In other words, don't change your testimony or don't testify.
Okay. And then, how about releasing the phone numbers to the public? In your view, does that cross the line, taking the phone number of an officer or of a private citizen and putting that out on his website? Is that something that you think is protected speech? Obviously, Mr. Bradel does, but from your point of view, does that amount to intimidation of a witness?
I think there's a distinction between your ordinary, if there is such an ordinary thing as putting somebody's phone number on a website and doing it to a witness in a criminal case with the intent to intimidate that witness. And I think this also relates to a comment that Mr. Bradel made. From the defense perspective, the court is to look at this with a very limited lens. Just look at what Mr. Kearney did. Don't look at what else happened. The fact that Mr. Kearney said, throw a rock or show up for an exhibit, or and that's a hypothetical, or show up for an event, or here's the phone number, go ahead and call. Well, he's not responsible if what results from that are a ton of annoying phone calls, obscene phone calls, et cetera. But I would suggest that that's the intent, clearly, that the grand jury could find in posting that, and that's the practical result of what's being posted. And the intent further is to harass and intimidate the witness.
Okay. Anything that you want to say that you haven't said already, Mr. Clausgrove, in support of your position? I know I started off by asking questions, but if you have anything that you want to direct my attention to,
Sure.
what you think is important, I'm happy to listen, and I'd offer Mr. Bradel the same opportunity. I've read everything that both of you have submitted. Well, let me start with Mr. Clausgrove, and I'll give you Mr. Chairman.
I'd just say a couple of things. First, I heard Mr. Bradel say there was no evidence of this and there was no evidence of that. And with due respect to my brother, I think he's making a layman's mistake in his characterization of evidence. When a witness testifies that I was watching a YouTube presentation and I heard Mr. Kearney urge people to order pizzas and not pay for them, that's evidence. Now, grand jurors can believe it or disbelieve it. The defendant can contest it in court if that same evidence is offered in court. But the fact is, it's evidence of what happened. So I don't think the statement that there is no evidence is accurate. I think in a broader sense, Your Honor, the difference between Mr. Bradle's position on behalf of Mr. Kearney in the Commonwealth is that when you ask, where is the line?
Yeah.
Mr. Bradle's position is essentially there's no line. The Commonwealth's position is that whatever might be the case, there's two lines of cases. There's the line that Mr. Bradle is relying on here. And he suggests that to be consistent with those cases, which talk about imminent harm and which talk about threats being made to the person's face and threats of bodily injury and so forth, that this statute must be unconstitutional and that it is to be construed consistent with these civil cases that he cites. And both of the cases that he mentioned are civil cases. The Commonwealth's position is that whatever the position towards the general public, and I alluded to that earlier, the courts have said that restrictions are possible when there are reasonable limitations as to time, place, and means. And we see that in a number of ways in cases that have been approved by the courts, cases that have recently had an approval of Judge Cannoni's order with respect to picketing in the Karen Reed case. That wasn't held as an unconstitutional violation. We have decisions in 209A orders where judges order, and I'd cite the court to the case that I didn't mention in my brief, Commonwealth versus Butler. What happened in that case, I think it's fairly well known. Your Honor may be familiar with it. Young woman on the day of her birthday went to her door and found some flowers that were anonymously delivered. I think we'd agree that if you send somebody some flowers on her birthday, that communicates typically a message. Hopefully the message it communicates is happy birthday. Unfortunately for Mr. Butler, about 3 months earlier, the court had entered a 209A order, no contact directly or indirectly. They traced the flowers back to Mr. Butler, was prosecuted, found guilty, the conviction was upheld. That sort of thing happens on 209A orders all the time, which ostensibly you could look at on their face and say, oh, this infringes on my right of association. This infringes on my right to travel. This infringes on my right to make witty satirical statements. Nevertheless.
But Mr. Kearney is a satirist. I mean, in essence, a lot of this is satire.
Well, I don't mean to be flip, but so what?
Okay. No, I mean, that's fine.
I don't think there's a special rule for satirists if the so-called satire is made with intent to intimidate.
Witness. Okay, that makes sense. Yeah, I see your argument.
I'll stop at this point.
That's fine. I'll give Mr. Bright. I'll give you just a minute. You've made your argument pretty well, but anything else you want to say?
There are some things, Your Honor. I just invite your attention to pages 9 and 10 of my brief, Judge, where the standard of how this speech is supposed to be judged is set forth. And just a couple of quotes. Speech on matters of public concern is at the heart of the First Amendment's protection. Speech concerning public affairs is more than self-expression. It is the essence of self-government. Speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. The Commonwealth is arguing the other way around. Give us the benefit of the doubt, Judge Doolin. Hey, evidence can be construed in different ways. Evidence needs to be linked to a particular person committing a crime. That's what they're lacking here, Judge. And this Janelle Webb conspiracy to run a license plate business, Your Honor, the Commonwealth indicted Ms. Webb, and then for some reason, and I think I know the reason, thought better of bringing the case to court and never arraigned her, never charged her, never did anything with that indictment, which I've never seen in my time. And I think what happened there was that the government, the state police probably realized that, hey, they run these plates on the sly all the time for boyfriends, girlfriends, et cetera, et cetera. And they don't want in the system a precedent where a police affiliated person, quote unquote, runs a plate and then gets indicted for a felony. And I think that's why that never saw the light of day. So there never was any conspiracy charge lodged against Ms. Webb. It's past the year presumptive speedy trial. So that case is effectively dead, Your Honor. That's an important fact the court ought to know. And also, it's not a crime to run a plate. So there was no criminal object of the conspiracy to run a plate. They just want to change, they want to erase the word conspiracy to run a plate, and let's put something in there, even though there's no evidence of it, let's put something in there that'll fly, like conspiracy to commit witness intimidation. There's no evidence whatsoever that 13B was implicated in any running of a plate. In fact, it's quite the opposite. It couldn't be more newsworthy. The district attorney had just gone on television with a remarkable statement vouching for witnesses in his case, that they were fine, they were on the up and up, and leave them alone.
That, but in terms of, so you're under indictments 14, 15, and 16. Your argument is that there's insufficient evidence for those to actually be a crime.
There's no criminal object. And even in the grand jury, Sergeant Tully admits, and he says it's not a crime, it's an administrative violation. He says words to that effect. You'll see it. And he does refer to that, and it's not a crime. That's why they couldn't say conspiracy to run a plate, against the rules, because it's not a crime. That's why they switch it to conspiracy to intimidate a witness. It's not intimidating to prove the exact opposite of what the district attorney said publicly, that these witnesses are affiliating with the state police and do know the state police and are visiting them at their home. So it couldn't be more newsworthy, Your Honor. And that's what was behind running the plate, was not to intimidate anybody, but to shine the light of day on corruption. Okay. So that's that. And Judge, another thing about, this First Amendment issue, and whether it's a jury question or a judge question, this is a judge question. You're not the first trial judge that, even in my practice, that has dealt with this. And I put this in my materials. You have Judge Walsh and Stoughton.
Yeah, there was two judges, right?
Right, and so this Judge Walsh actually did two things, Your Honor. He did Mr. Schiffer, who's here in the courtroom today, and I appreciate it. My other client, Mr. Schiffer, is the guy that put rubber ducks all around Canton with political statements about the Reed case. And remarkably, the Canton Police Department did a 37-page investigation that was, if they applied that much work to the Reed case, those folks wouldn't even be here anymore either. But they did a 37-page investigation into Mr. Schiffer putting rubber ducks all around Canton. And that's the Judge Walsh opinion, and you'll see it in there, denied on First Amendment grounds. It's not witness intimidation. Denied on, and arguably.
But there's a difference between that and saying we're going to make the white miserable, isn't there?
Well, Judge, that's O'Brien v. Borowski. That's foreclosed by O'Brien. Fear of being sued, fear of being yelled at, fear of being embarrassed doesn't cut it. If I just could have one moment.
Yeah, no, take your time.
So Judge, with respect to these rubber ducks, it's the exact same kind of thing that Mr. Carney's accused of doing, and it's thrown out on First Amendment grounds. It's Colin did it. It's, statements about the case. It's the same kind of thing. And, they went after him. And that's what happens when these kinds of bad statutes get used for ulterior motives by self-interested police and prosecutors.
Thank you so much. It's been a wonderful argument on both parts.
Thank you.
Both groups were very good as well.
Thank you.
I'll take it under advisement, and I'll have something for you soon.
Thank you.
All right, thank you.
Your Honor.
Next scene, please.
Oh, yeah.
What's your obsession?
Let me just, can I talk to the lawyers at side for a minute?
Maybe over here.
Mr. Glasgow, the floor is yours.
Yes. Your Honor, I can just take a moment. This morning, I was informed that there was an incident last night. Apparently, the defendant and a friend were at CF McCarthy's, which is a bar in Canton. It's next door to D&E Pizza, which is owned by one of the witnesses in this case, and his son, who is also a witness in this case, and I should say they're witnesses in the Karen Reed case, works there, and they are both victims listed within the indictments that are before your honor. At the end of the evening, the son closed up at D&E Pizza and went home. There is a video camera, possibly more than one, but one in particular in the window of D&E Pizza. And what it recorded was that Mr. Kearney left CF McCarthy's next door and in the company of a friend, or shortly joined by a friend, walked up, either noticed or had previously noticed the video camera, and walked up to the window quite close, pressed his face up against the window almost, and then stepped back for a moment or two. Spent a couple of minutes just staring there, and then went into a 2-minute diatribe saying hello to the witness. What have you done? I wish he was alive today. Why did you do that, Chris? He's talking to Chris Albert, the witness. I just want to know. Then he goes on to say, and I have to paraphrase from here, Your Honor, because I didn't get it all down in the brief time that I viewed it. But I know you didn't do it. Colin did it. And then he goes on essentially to ask why he is covering up for his son, assures him that he's not trying to frighten him. He just wants to know. Just wants to know. Now, at that point, he walked and went away, leaving Mr. Albert to find that the next morning when he reviewed his video. Now, we can talk about how many legal angels dance on the head of a pin here, Your Honor. I think I could do Mr. Bradle's argument for him. It's just speech. Nothing's meant by it. It's protected. I doubt I've saved him the trouble, but I've tried. At this point, I don't think it's an issue whether technically it meets the standards of intimidating witness. I think certainly the attempt, at least in the colloquial sense, was to harass and intimidate. And we always talk about these in isolation, Your Honor, but there is a drumbeat every week of verbal attack after verbal attack on the witnesses and the officers in this case. So at this point, I am going to ask the court to set bail on Mr. Kearney. He's been released on his personal recognizance. And I am also going to ask the court to set conditions. And those conditions will be no contact, direct or indirect or through third parties, and I mean no contact in the broadest possible way with any of the witnesses or officers testified for the Commonwealth in the Reed case or any of the alleged victims in this case. And I am going to ask that Mr. Kearney, as a condition of his release, be prohibited from approaching anywhere within 100 yards of a victim's residence or within 100 yards of a victim's place of work.
Okay, thank you. Mr. Brady.
Thank you very much, Judge. Judge, this is not how incursions of someone's liberty are done in Superior Court or in any court that I know of in the Commonwealth of Massachusetts. I don't have a shred of paper. I don't have a shred of documentation. I don't have anything on this issue.
You want to continue? I'll give you one.
Yes,
I mean,
certainly.
look at it.
Yes,
You want
absolutely.
to come back tomorrow?
I don't think I can come back tomorrow, Your Honor, but the government should be sent out to go get their ducks in a row, no pun intended. And
Maybe we
Then
could
if
borrow
they have-
Mr. Kearney's.
if they have an issue, then they should come back for it. But you don't say, hey, I heard this thing happened and
Why
I
don't
want
I
to.
do this? Why don't I do this? I'll give you 24 hours, Mr. Brady. We will absolutely have a right to review the video. We have a right to see any reports that were written. I'll see you both back here at 2 o'clock tomorrow. Does that work, Martin?
I was going to suggest noon.
How about noon tomorrow? Does that work? for the both of you?
That's fine, Your Honor, and I don't mean to prolong this unduly, but I just want to say I became aware of this incident that happened last night at 10 o'clock this morning.
That's fine.
So,
That's great, but the government should do some investigation and, give me a chance to say
Yeah,
something.
we'll address it tomorrow at noon. In the meantime, Mr. Kennedy, just stand up, stay away from that pizza place, okay? What was the name of it?
I'm sorry, Your Honor, it's D&E Pizza.
Okay, just stay away from that, and then we'll address it tomorrow, okay? All right.
So the matter is continued to March 6th at noon. Mr. Kearney, you are ordered to stay away from D&E Pizza. Do you assent to this condition, sir?
Yes.
And you're hereby notified if you're charged with a crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58.
Okay,
Thank you.
thank you all.
Thank you, Your Honor.
Hi guys, I don't know if you can hear me. But Tommy, if you can unmute your mic.
The very people. Hey guys, hold on.
You did that last week to me.
I just hit the
and
live
I
now.
wasn't on mute.
No,
Get away
I
from me.
unmuted. There we go. I think. There we go. Good morning, everybody. Yeah,
No.
that was yesterday. Did you guys happen to notice all the case law that Bradel was referring to? Me and Scott were talking about that. How does the law get to a point where you can even get witness intimidation charges on somebody else spitting on your lawn? And Aiden have zero to do with that, right?
Third party thing.
Well, if
I do something,
right,
just because I support Aiden,
right,
does not mean Aiden told me to do it.
he didn't direct
He did
you.
not do it
We didn't give you the idea.
Right.
That's just you. So if you buy an electric car,
Yep.
and I have electric cars, and I go do something with my electric car, you got one. Doesn't make you guilty.
Exactly.
That's what they're saying.
I know. If I chose to go do something right, which
Correct.
I wouldn't do.
No, I know you wouldn't.
If I chose to go drive to like one of the McAlbert's houses or something,
Right.
stand outside,
Hey!
or even D&E, or even D&E, right?
Right. I
Like
mean,
A&E is not telling you to do that, but
correct.
they will charge you.
It's ridiculous,
It
isn't
makes no sense.
I mean, it's hard to come up with an analogy because it's so out there. It's so wide out there. It's just, yeah.
Tom, the last time this witness intimidation statute was amended was 2013.
Okay.
And somebody added all this emotional distress
After the
and
fact.
financial crap to it.
Yeah.
And that's got to be removed from the statute. Morrissey has weaponized it.
So would you say that if they pass a law, right? You can't go within 1,000 feet of a victim. That's okay. But when they come back after the law's already in place and say you can't visually see somebody, so by not being 1,000 feet from somebody, okay. But if I see you past 1,000 feet or under 1,000 feet or whatever, it's so stupid.
But Allison, you got to let me know and I'll say.
I mean, Scott, you're probably committing a couple crimes right now. Somehow.
I mean, think about it. Every time the McAlberts walk in and out of this courthouse,
Yeah,
and us protesters are out here, can't they claim emotional distress?
sure can.
And we're all witness intimidating?
Listen, these people driving by, right? They're viewing this, right? They got to be affected somehow. This news guy here, right? He's going to go out on PTSD here.
I think we send you guys over to Morrissey's office. We just didn't cross. I know. Channel 5.
You're absolutely correct. The 209A laws. Remember that? Yeah.
It's fucking crying out to turn.
We all had to sit through Lally. That's emotional distress. Oh, is that the North Carolina trooper that's in here? Good to see him if he's here. Good morning, my friend. Good morning, my friend. Wow. So yeah, so now that everybody's here, welcome. Thank you for being here. Please hit the like and the subscribe button so that when this happens again, you'll get notified. That's Neil. Neil's been coming to stand out for a long time. Like he was, again, one of the original no problem. Have a great day. Yeah, there's I think a lot of people are feeling some stress. I really do. I mean, this is a lot, right? It's a lot for everybody. So, yeah, right? Exactly. You're all getting locked up. But again, like really, there has to be a way, right, where we can protect the well, okay. There's got to be a way we can protect the domestic violence victims in this while using our head. I mean, the digital age is here, right? What if you had, you know, a device that was like a what do you call it there? Like a tile, like an air tag. Yeah. So all the domestic violence should have air tags, so that if the air tags can monitor where everybody is all the time. All right. You want me to spell right? You want me to put an E at the end of that? You can fix that, I think. Easy stuff. Maybe not. Uh, Fixed it. No, no, no. Listen. Listen. There we go. Morning. Good luck, guys. All right. You look real confident in that. Um, what else? Yeah, Bedrow and Cradle. Wow, that was crazy. What was I saying? Yeah, Bedrow and Bradle. They do a lot, and I know Aiden does a lot. I mean, he provides all the documents and supporting information for his attorneys. But you know, I'm sure Miss Meredith has been doing just as much work in this whole thing. So you know, you can't forget about his significant other, who I'm sure is doing a lot to support Aiden. You know, and you guys all out there supporting him also is a big thing. So yeah, and these people here are all getting ready to go in the courtroom. Jessica Machado is here, just so you guys know. She's already here, so we know that she'll be tweeting from inside the courtroom, which is great. One news. Is it that bad, man? What's up? I have radio check. That sounds, is my mic any better now? I changed it. Microdots, it doesn't compare to anything remotely close to what you put out there. I can't say enough about your content and how amazing it is. and how accurate it is and how telling it is. So yeah, everybody please go to Microdots, like, subscribe, give the man some love. Yeah, fabulous work. Fabulous work. My pleasure, my pleasure. And again, right? Tell me we're not blessed to have as much talent in the talent pool as we do, right? So yeah, this guy coming looking yelling at us, get out the stairs, right away, get out the stairs. Jesus, can't have a conversation. It's like they're protecting the Fort Knox or something in there. Wow, Canada. Wow, like that. No doubt, huh? But yeah, and again, right? The talent in the just the people that we have. I mean, it's ridiculous. How you doing? Good. Good morning. Are you guys going in?
Oh, we're gonna find.
Yeah. Okay. I know if they're trying to say something. Yeah. Yeah. How's everything? Good. Situated? Yeah.
Figured it out. Yes. Yeah. You know, it was totally legal. I think I have to judge.
Good.
Uh,
Good. Good.
yeah, she put big threat. Yeah.
You on film?
Yeah.
Good. No?
No. But you know,
It don't matter.
I
No.
talked into my logo.
Right.
Uh,
Right. Right call. Right. You call to check in on her? Yeah.
yeah.
Shout out, Sarah.
Yeah.
That's good.
Yeah.
Take one.
Yeah.
I'm gonna share this one, so I'm gonna throw it. Seriously? All right.
Yeah. 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 Well, I mean, she just drinks alcohol. You know what I
Right.
mean?
Heads up. Right.
Yeah. So somebody knew.
Right. Yes.
You know
Thank
what I
God
mean?
too.
If eyes are not watching shit and just
You know. Yeah. I absolutely do. Yeah.
everything is not just understand. Just understand. As far as the housing prices, it's totally
You ready?
reasonable.
Ready for this? How much money do you think they made on this price? I'm sorry. No. I'm sorry. On still tax.
In
Vehicle.
Massachusetts,
The vehicle.
yeah.
You buy these vehicles.
Yeah.
Still taxes paid when it was bought new. Still taxes paid when it was bought second. Still taxes paid when it was bought third. Still taxes paid when it was bought fourth. Same vehicle. How
Yeah.
much money are they really making? Where's it going?
Yeah.
Michelle Wu's in DC, so we have eyes on that. We gotta fix that first. Rhode Island's too small. It's all corrupt. It has to be. Don't tell me it functions and everybody knows it. Whatever. Yeah, it's nothing but stress on you. Sometimes it's better just to walk away, because your mental health and the anguish and what it brings on you ain't worth it. Just walk. Yeah, I know. But the time it takes out of you and your soul and your brain power is just, I've been there. I know exactly what you're talking about. It's just, no, it's a lot of work. My friend wrote a writ. Dedham, please. Oh my God. He wrote a writ. So he took me under his wing and he did a nonprofit in New Bedford. We went out to the city of New Bedford in the state of Massachusetts, at the DEP. And then we went to EPA. And EPA is the only one that responded. When they came to town, they had to play New Bedford for up children. And it was great catching them. And people were resigning. This one's resigned. It's just, yeah.
That's what I was a state worker. I was a state worker. I got injured on the job and I fought back. And I didn't like that. They don't like it when you uncover their shit.
Yeah.
You know?
I do. Yep.
Have problems.
All right, listen, if you need anything, if either one of you guys, just give me a ring.
Thanks. We're
Okay?
gonna try to. I'm gonna try to launch this to get.
Hey,
Is it true that like I was gonna go on your, or you were gonna come on my,
Yeah.
or whatever, within an hour of when that happened?
I know.
Within an hour.
Yeah.
Stuff like that
That's,
happens.
to me, was like, that's fucking
You're on the
weird.
list.
There is. I'll talk to you later. We'll figure something out. We'll talk about it. Oh, good morning. Good morning. This is my head's full already. It's just amazing, dude. The stuff that's going on out there. It's criminal.
Brado's not going to stop. He'll take this all the way to SCOTUS.
Right?
It's intimidation law.
If you're gonna do it, this is the one to do, right? You got the right bench now, right? We have the majority. No?
No,
We got
the only
we
way
got
you're going to
Supreme
change the
Court.
witness intimidation law in Massachusetts is you got to get the legislature to change it. They're not gonna. So then you have to go all the way to Washington D.C. to change.
Aiden needs to be found guilty. It needs to get appealed to the Supreme Court. Supreme Court's got to deny it. Then it's got to get appealed to the United States Supreme Court.
Yeah.
And that sucks. We don't want no one found guilty for nothing, especially when you didn't do nothing. Nice. The girls got the Zoom up already. Good job, ladies. Thank you. Yeah, there we go. Give you guys a little bird's eye view here. Morning, bud. Good morning.
Morning.
How are you today?
I'm great.
Great, great. Have a wonderful day, sir. Nice. This is awesome. Nope, they're not letting anybody in the courthouse. Why is that? Why can't they go in? Why can't they go in?
Chief Rose was saying that there's something else in the courtroom right now.
Oh, the Colleen, crazy Colleen from Canton? Gotta be.
So I don't know if they're bullshitting or
That
there's
is
something
her.
going on.
Colleen's here, everybody. But she put her sign over the other sign on the street, and they went and took it.
Okay, Monday night.
So it's 12 o'clock. There's still somebody in the courtroom, guys. And that, I believe, is why they have all the people out here still. And I think there's something going on in that courtroom. So I don't know why they're not. I mean, obviously that would be why, but I don't know. I just hope this judge already had lunch. Unless he wants to just walk in and say, let's just make this go away. Dismiss. Boy, I just saw you, what, 12 hours ago? Great. Why have they not let us in? So I'm told that right now there's the room. There's still something going on in that courtroom.
Oh, so they don't want people in there.
Correct.
I'll have a cigarette with you.
Yeah. Relax.
Hang out. How are you?
I'm doing great.
You have a nice winter?
My winter, let's see. Yeah, it was. Yep.
I'm glad it's over.
Yeah. Spring's coming, right? We didn't get hit with all that snow they were predicting. I mean, yay! All right. Enjoy the time in there and enjoy your rear end while you have. It's gonna hurt. Good to see you. Keep fighting. Yeah, my sister loves you beyond belief. My sister, if she knows you're here, I'm gonna hear about it. Oh my God! Hey, have fun in there. My sister loves Colleen like there is no other. She thinks like Colleen is just so. My sister, if she was here, she'd be all hugging her up and stuff like that. So, oh, Kathleen, good morning. Good afternoon, I should say. Hope you're doing good. You've been with me for a long time. From the freaking beginning, actually. Isn't she? Isn't she? I love seeing strong women like that. Yep, definitely. Uh, Good news. Awesomeness. Awesome. So, while everybody's here, can you just hit that little like button, subscribe button in between? It all helps. Busy place today. Yeah, and you know what the thing with Colleen is, right? Is she works at the thing at I don't want to give the name, but she works at a place in Canton, and the cops would come, right, and try and like intimidate her and like push themselves around and try and scare her and stuff like that. And if you know her, she ain't putting up with that. Not that she puts it back, but she won't accept that, and she doesn't. But the fact that the police department goes out of their way to target this lady, that's unacceptable. And that's Canton Police Department, right? I mean, many times she's been by herself, and the cops have came and pulled up right out front of her place. It's ridiculous. But she fights back, no doubt. She ain't putting up with that. Yep. I think he's pro Karen, Reed, pro Turtle Boy there. Let's see, Chrissy, Aiden, Bradle, and Bedro and Meredith all walked in. No, it was very uneventful. And then they just opened the doors to let everybody else in. And there's the end of the line still going in. Now, the reason that we started late is there was a case going on in the courtroom that they're going to use for Aiden. So I think they had to wait for that to clear out. Bring it in. They really do. They really do. They intimidate. I know they intimidated Colleen. Oh, I'm sorry. I know they attempted to intimidate Colleen. She's not one you're going to walk up to and intimidate. You can try, but that won't work out too good for you. What do I think will happen? I really think that the judge will maybe listen to everything today and take it under advisement. I don't see it. I don't see it happening. I just can't, because I was talking to Scott about it. You know, all the case law that's already out there, they've changed the case law from what the intention of it was into something that is now open to interpretation versus it being, straight black and white. They've taken and added some gray here, some orange, some purples, and yeah. And now Morrissey's trying to paint a friggin' Mona Lisa with it, and it ain't gonna work out too good, I don't think. Miss Shelby is working. She's been working her very hard lately. So yep. You know what's awesome with Pauline is like she she'll hit live and then she'll just like open her mail or something like that. But like she's very good with the on the fly type of a stuff. No, I didn't see that. But I have to go through. Somebody sent me pictures of Bev and Morrissey at a party in someone's backyard. I got pictures of them and stuff, so I got to go through and find them. Um, right. Gail, right on the money, Gail. Yes, you're right. However, right, yesterday the troopers were all acting really sketchy. Okay, they all park over here. None of them had their body cameras on. Oh, Peppa, thank you, Peppa. You didn't have to. Oh, thank you, Peppa. Thank you. Yeah. So, Scott, the charges were filed in Stoughton. Aiden's here. They can't take them charges and pop on him here, right? He has to go to Stoughton to face the charges in Stoughton.
He'll have to do that also.
Also, they can't take. They won't pay. Could they? You know what I'm saying? Can they take him?
No, because he's on conditions of bail.
Can they revoke his bail here?
That's why it's a superior court issue.
But can they
But as
revoke his
far as
bail?
the actual charge, he still has to be arraigned.
That's right. But they can't. Oh, heads up.
No, they can't.
You understand what I'm saying? Because he's here, they can't pop him here, right? And take him out in cuffs, right?
No, it's
Right?
the
Stoughton charges won't carry over here, right?
Just like when he got locked up last year.
Right.
That would be a worst case scenario.
Mary Smith, oh my God, paid me $20. Thank you. Oh my God.
But what he's charged with has to be arraigned at Stoughton.
Yes.
But the problem is he's already on bail.
Bail from here.
Right.
So can them charges from Stoughton revoke his bail from here? You see my thought? Like,
Could, it's probably not.
no,
It
but
could.
yeah, yeah.
It was more complicated last year because I had to do it at domestic. You know what I mean?
And there's no domestics between him and a freaking
No, yeah.
him and someone's house.
All he did was went in front of D&D Pizza and talk shit into the camera.
To keep it,
Chris Albert didn't see it till the
a
next morning.
building can't be violated like that. A building can't,
Melanie,
unless,
Melanie
wait a minute,
Little's reading the report. Right now.
unless, wait a minute, unless they put in the motion Chris Albert in his business.
No, she's reading that report right now.
All right.
So that's what
All
they're
right.
going to be talking about.
So Melanie Little's reading something about that. Conflict of interest. We got conflicts on top of conflict. Oh, Lord Tessa, thank you so much, my friend. Pepper, give Brutus a kiss.
Sometimes I screw people up. I wear the pink one.
Yeah. Give,
Morning, you have reached the Zoom for courtroom, the main courtroom in Norfolk Superior Court. We just ask you remain on Zoom during the hearing. Thank you.
Yeah, this could be real quick, or you don't know.
That's what I was thinking. I have no idea.
I guess I muted him. I thought I was being so true.
All right. Discussion may be.
Oh, my own.
For the record, before the court, numbers 4 and 5, Commonwealth versus Aiden Carney, 23 CR 313, 24 CR 43. Mr. Carney is present, along with his attorneys, Timothy Bradel and Mark Federow. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for a bail hearing. If the parties could please identify themselves for the record.
Good morning, Your Honor. Robert Cosgrove for the
Hi,
Commonwealth.
Mr. Cosgrove.
Hello, Your Honor. Tim Bradel on behalf of Aiden Carney to my left.
Okay.
Your Honor, Mark Federow for Mr. Carney.
All right. Good afternoon, gentlemen. You can be seated. Mr. Cosgrove, I've seen the video. Go right ahead.
All right. Well, thank you, Your Honor, for hearing us today. I have a couple of things that I would like to do. Your Honor has seen the video. I want to put some observations about the contents of that video on record, and I want to draw on the police report, a copy of which I have provided to counsel. I'm going to read excerpts from it that I think are significant because aside from summarizing the contents of that video for the record, they also summarize somewhat the reactions of the Alberts upon viewing that video. Lieutenant Tully's report would indicate that at approximately 8:15 in the morning yesterday, he spoke with Chris Albert, who, as Your Honor knows, is a witness in the open Superior Court case of Commonwealth versus Karen Reed. Yesterday in the presentation, I referred to a number of incidents which Mr. Kearney was indicted for, which the Commonwealth alleges constituted intimidation of the witness with respect to Mr. Albert and with respect to his son and to other witnesses in this trial as well. And I made reference at that time to the videos, which I believe you have been provided by Mr. Bradel in his filing that were played before the grand jury that record some of the background. And I think that's important, Your Honor, because if we're talking about, to draw an analogy, Chinese water torture, it's not the current drip, it's the accumulation. And I think whatever one thinks of this video, it has to be placed in that context. Lieutenant Tully continues that Mr. Chris Albert, who I will refer now to avoid confusion simply as Chris, sent him emails with 2 videos from March 4th. They are from his restaurant, D&E Pizza, on 618 Washington Street in Canton, depicting Mr. Kearney. One video depicts Kearney walking down the sidewalk from the direction of C.F. McCarthy's, which is located next to D&E Pizza at 614 Washington Street. And a group is seen leaving C.F. McCarthy's that later joins Mr. Kearney. Mr. Kearney stops in front of D&E and places his face next to the front glass window of D&E. An interior camera captures Kearney standing close to the glass, staring into the camera for approximately 25 seconds. A male with that group then exited C.F. McCarthy's and joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute. The audio is captured by an exterior camera. The sound of occasional passing motor vehicles obscures the audio, but Lieutenant Tully could discern what he describes as the following statements made by Kearney. And I pause at this point to put on record what the court already knows, which is that subsequent to the Lieutenant Tully's composing this report, we made efforts to merge the 2 videos into one video and to enhance the audio. So that is what your honor was presented with. The videos themselves were not changed in any way, but they were merged. So essentially you see them both playing at the same time, and you hear an enhanced audio, which in my view is still not great. As Lieutenant Tully heard it, Mr. Kearney said this: "Hi, Chris, what have you done? Murdered. Something's inaudible. Misses you. Wishes he was alive today. He would be. Why did you do that, Chris? Chris, why did you tell the jury that you got home? Why did you say you went upstairs and then waited 15 minutes? Then Colin came home. Colin didn't make it home until at least 12:45, Chris. It was Colin, Chris. Colin. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why Colin did it. You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. Tell Jill to keep their hands up to herself, too." Those are the statements he made in his conduct standing outside D&E Pizza. Similar to the conduct that was the basis for his indictment, and Your Honor has probably viewed at this point the video of the defendant standing outside D&E Pizza accusing both of these parties of murder. When Chris saw the video shortly after the incident, he became upset. He stated he's upset for his son Colin and the possibility that Kearney would continue to come to the restaurant and confront him and his son. And that's basically the report, Your Honor. Your Honor, there are 2 Aidan Kearneys. There is the courtroom Aidan Kearney, as is presented by counsel. Is careful only to exercise his First Amendment rights, and in no way does he have anything to do with the things that have happened continuously to the victims in this case as a result of his continuing broadcasts and other activities that have continued since his indictment. If Jennifer McCabe is getting anonymous letters threatening her, Your Honor, with having her head chopped off in prison, if if her daughter's school is getting phone calls and letters asking her professors if they knew they have sitting in their class the daughter of a murderer, if Mr. Albert is getting phone calls, if people are photographing him on the street and sending those photographs when he's trying to enjoy his dinner or he's at the beach to Mr. Kearney, who posts them.
Okay, your objection is noted. Go right ahead, Mr. Cosgrove. I'll hear from you later, Mr. Bradle.
Who posts them on the internet, that has nothing to do with him. He's only responsible for his own conduct. Your Honor, a few days ago, Mr. Kearney was standing outside this courtroom waiting for a Karen Reed hearing, which he was covering in his supposed role as a reporter. As he went up, he was filmed by another one of the Karen Reed supporters. He was filmed for a, quote, live show by Tom CPU. He's a Reed supporter and a YouTube personality. And this video of Mr. Kearney's interview was subsequently posted on one of the free Karen Reed video shows. I watched that video, and I wrote down what Mr. Kearney said just about 2 weeks ago. It was brought to his attention by the interviewer in a friendly way that word had leaked out that all of the threatened actions by the U.S. Attorney's Office, which the witnesses in this case have been threatened with, they're going to be indicted, they're going to be marched to jail. District Attorney Morrissey's phone is being tapped. The police are corrupt, they're all going to be indicted. That investigation, if it ever was an investigation, it concluded with nothing, zero, nada. Kearney was asked about that, which at that time was a rumor. And here's what he said. They all know what they did. It's just so obvious. Like I said yesterday, if they are never charged, okay, they got away with murder. Congratulations. They got away with it. But I have successfully made it. So no matter where they go in public, if they walk into a restaurant, the people will always look at them funny, and they will be like, oh, there's the people that murdered John O'Keefe. When they walk into a restaurant and they look around them, they have to be thinking, who here thinks I'm a murderer?
Judge, I object. I move to strike. Counsel, is he counsel for the Commonwealth? Is he a witness testifying? I have no notice of any of this stuff. What's going on here?
Okay, your objection's noted. I'll hear from you, as I said earlier, Mr. Bradle. Go right ahead. Mr. Cosgrove, what's your recommendation? What do you think?
What's my recommendation? My recommendation, Your Honor, is one, that the court enter a stay-away order with respect to any property in which any of the witnesses in the Reed case for the Commonwealth or in any of the pending indictments against Mr. Kearney, and that stay-away order require him to remain a distance of at least 100 yards from any of those locations. My second recommendation is that the court enter an order with respect to all of those same people, the witnesses in the Commonwealth in the Reed case, the witnesses in all of the currently pending indictments against Mr. Kearney, that there be no contact with any of those victims, direct or indirect, through a third party, by any means whatsoever. And I hesitate, given my own respect for the First Amendment, to make any recommendation as to what Mr. Kearney can say. However, I note that to accuse someone of murder, is defamation per se. It's a tort. It's not the only tort that Mr. Kearney has committed along the way. There's been invasion of privacy. There have been others. A witness can come to me and say, you know, what can I do? What can I do to stop this? I didn't sign up for this. I agreed to testify. I answered your questions. I agreed to go into court. I agreed to be cross-examined, redirected, challenged. I didn't sign up for 2 continuous years of shame. Now, I don't know what I do, Your Honor. I don't know if I say to them, well, I'll tell you what. Get yourself over to the civil court, file a civil suit. You've got a pretty good defamation case against Mr. Kearney. And after you pay a lawyer $10,000, $50,000, whatever the going rate, maybe you'll find somebody to take it on contingency. And after you've been deposed, and after you've sat in court and been to court a number of times, and after there's a trial, you might collect a pretty handsome amount of damages. Of course, that's going to be 2 or 3 years down the line. But I am helpless, Mr. Witness, in a criminal case. Remedy. I think that's all just First Amendment stuff. That's not intimidation of a witness. I'm not sure what I do, Your Honor, but I'm going to ask you also to set a condition that there is to be no defamation of any of these witnesses. Finally, I'm going to ask you to set some bail in this case. I was not involved in the case. I understand a request for bail was made originally, and for some technical reason, it was not allowed. And I acknowledge that Mr. Kearney, since he has been indicted, has been faithful about showing up to court. I have no reason to think that he will not show up to court in the future. I think he regards it as another opportunity to put on the Aidan Kearney show outside. But I do note that he's facing charges that carry substantial penalties, that are felonies, and that if a jury should see it my way after trial, I put the defense and the court on notice that I see his conduct since these indictments have been brought as aggravating circumstances, and I will certainly take that into consideration if I ever have the opportunity to make a sentencing recommendation. I would suggest what would be a nominal bail, 10,000 surety, 1,000 cash, but pray Your Honor's judgment in that respect.
Okay.
If I could say just one final thing.
Go right ahead. You go right ahead.
I think I'll think better of it, Your Honor. Mr. Bradel can bring to the court's attention what I was about to tell him if he wishes, and I will not get into discussions with counsel.
Okay. Mr. Bradel.
Thank you very much, Your Honor. So, Judge, just a procedural objection. There's no paperwork before the court. There's nothing supported by affidavit. I'm just hearing counsel's recommendations right now. So I'm responding to this on Mr. Kearney's behalf, basically off the top of our collective heads here. So that's kind of where we're at, and I would just object procedurally. Nonetheless, we have, a lot we want to say. It's hard to sit here and listen to the Commonwealth with scorn, say that he wants to put on the Aidan Kearney show. Well, yeah, you're darn right he wants to put on the Aidan Kearney show. It's his First Amendment rights to do so. And the Commonwealth, for a year and a half now, has made every possible effort based on their own self-interest. The particular prosecutors, the particular state police detective unit, present prosecutor accepted, to suppress a viewpoint that's been raised against those very same people. So that's what we have here at the outset, Your Honor. As far as this particular motion goes, how far are we going to let the Commonwealth surf this wave? You saw the video. The case at bar, Your Honor, had no stay-away order from Judge Krupp, had zero bail, nothing, not even the stay-away orders, Your Honor. Mr. Carney was not in violation of anything whatsoever when he did what he did. And in terms of the government, again, out of their own self-interest to suppress his critical viewpoint of them, the government wants to try to tell the court that this is witness intimidation. And as we comprehensively argued and briefed just yesterday, this is not witness intimidation. And the purpose of bail, Your Honor, is not to punish under Section 57 of the bail statute that governs Superior Court and Commonwealth versus Brangen. There is no allowance for punishment. Nonetheless, Your Honor, Mr. Carney has agreed under Section 87 to stay away. And he's agreeing to stay away from the pizza shop, agreeing to stay away from Mr. Albert. But I should say, Judge, again, this goes to how far are they going to surf this wave? Chris Albert and Colin Albert, Your Honor, are no shrinking violets. They're on camera threatening Mr. Carney, threatening to kick his ass up and down the street in 2 seconds, calling him a pussy. These people are not shrinking violets. They're only shrinking violets when they see an avenue to strike out at Mr. Carney. And now, was it unwise what he did? Yeah, you wouldn't have done it, I wouldn't have done it. Nonetheless, what do you do about it? You don't punish someone, you can't punish them for it. Look at his track record. He's not a flight risk. He has no record whatsoever. He comes exactly when he's called, anytime he's called to answer for this case, and he always will. And he's got kids in Worcester, and he lives in Worcester and Southie, and he's not gonna have any sort of flight risk issues. Nonetheless, under Section 87, Your Honor, we would agree, preserving any procedural objections, we would agree under Section 87, Your Honor, to stay away orders from the witnesses, stay away orders in this case and in the 24 matter as well. However, there's one thing that we're very concerned about, Your Honor, is that there's been a history of these witnesses using these types of orders to flush Mr. Carney out of court. And we ask that you look at, in terms of an agreement, Your Honor, under 87, we would propose that the court adopt Judge Pomerol's order across the street, which was stay away, but not with respect to courthouses, so Mr. Carney can do his job, and so they can't abuse any court orders to flush him out of court to stop him from covering these cases. So I would ask that you by agreement, again, allow him to stay 100 feet away from these people. And in terms of courthouses, he is allowed to be in any courthouse of the Commonwealth plus 300 feet curtilage, so he can come and go without accusations, such as we are actually dealing with in another case, Your Honor. But that is essentially Judge Pomerol's order, and we would be agreeable to that under Section 87.
Just say that again. Give me Judge Pomerol's order again.
Sure. The gist of it, I'm not saying it's 100% accurate. The gist of it is that he can go, Mr. Carney can go to any Commonwealth courthouse without worrying about the stay away order, and within 300-foot curtilage, so he can come and go without these accusations that he's violating some order. And that's essentially what Judge Pomerol did, and we are agreeable to that here under Section 87 in light of what's transpired, and reserving the rights, of course, to address this as these allegations as having nothing to do with witness intimidation. There's no threat, there's no fighting words. He's talking into a window at 10:30 at night. And again, you might not do it, I might not do it. Unwise, sure. But what do you do with it? You can't surf this wave for miles and miles here. It's ridiculous. And he's acknowledged it. He's agreeing to it. I ask that you would adopt our suggestion, Judge, and let it be. Thank you.
Okay. Thank you both for your presentations. I'll note a few things for the record. I watched the video. Unlike some of the things that we talked about yesterday that were in the enumerated allegations of the indictments on the 2023 case, there wasn't any camera that was being used by Mr. Kearney. There was no content creation. I still do have to look at it, I suppose, under the First Amendment and balance that with what Mr. Cosgrove has said about the witness intimidation in the case. I also note that Mr. Kearney has two cases that are pending before this court, and one that's pending across the street, as Mr. Bradel referenced, in the district court. And it may result in a fourth case for his actions the other night. I don't in any way, I've taken a look at his record, which doesn't have much of a record. I also take into account that he has been to court on every single occasion. He's always here with counsel, and my view of him, he's always behaved according to the way that one is supposed to behave in court. So I certainly respect the Commonwealth's recommendation in the case. And what I am going to do is I'm going to make a further order on this case that he's to stay away from all of the witnesses who are enumerated in the counts of the 2023 case, and also for the witness who is enumerated in the count of the 2024 case. He's to stay away from those witnesses. He's also to stay 100 yards away from D&E Pizza. And he, I think that what Judge Palmer has ruled upon about his coming into the courthouse, he comes into the courthouse as a journalist. But I'm going to suggest that when he comes into this courthouse, that he behaves according to the sentiments that have been expressed here. And my order to him is that he's to behave in an appropriate manner and not to in any way try to intimidate or harass any witness. And that would also extend to 300 feet around the courthouse so that he can get in and out of the courthouse during the Reed trial. So that's my order on the case.
Judge, may I ask, in terms of the stay away order, and I think this is typical, are you accepting the defense team, investigators, et cetera? We need to talk to witnesses.
Absolutely. The defense team can reach out to witnesses if they want. That's what defense attorneys have to do to defend their clients. So you can have an investigator or yourself, Mr. Bradel, or learned counsel, Mr. Betterow, as well.
Thank you.
But I don't want anybody else to be reaching out to witnesses.
I understand, Your Honor.
I also have a question.
Go right ahead, Mr. Cosgrove.
I don't mean to press your honor too hard on this. But I noticed as you announced your decision, you indicated 100-yard stay-away zone.
From the B&E Pizza.
From B&E Pizza, which I appreciate. I think it would be very advisable to extend the same order with respect to the homes of the witnesses in these cases, given the history.
Let me talk to Mr. Bradel about that.
Can I have one moment, Your Honor?
Yeah, why don't you talk to your client?
Judge, we'll agree to that under Section 87, yes.
That's fine. Okay, so it would be the same thing, 100 yards away from the homes of the witnesses in the case. Why don't you give me a next date that works for all counsel on the case? We still have the matter from yesterday under advisement.
Judge, we have, just reminding everyone that you mentioned that 10 days we want to address or file pleadings relative to the journalist issue in the team. Should we pick a date, maybe 20 days out, 30 days
I'd
out?
say probably sometime at the end of April.
End of April.
What, April 23rd?
I'm not a good week, Madam Clerk. Can we go the next week?
That's fine.
April 1st, or, I'm sorry, April 30th.
That works for us.
All right.
Unfortunately, I've neglected to bring my calendar with me, so why don't we say April 30th, and if there's a problem, I'll consult with Mr. Brado and get back to
That's
the
fine.
court.
Okay.
That'll be-
Thank you.
be
Okay.
issued,
Thank you.
Thank you, Your Honor.
Attorney, your conditions of release are amended as you are ordered to stay away, have no contact, direct or indirect, from all the witnesses in your 2023 and your 2024 cases. You're also ordered to stay 100 yards from D&A Pizza and the residences of all the victims, the witnesses in these cases. And you are ordered to behave in an appropriate manner while in the courthouse and 300 yards of the curtilage. Do you assent to those conditions, sir?
No.
And you're hereby notified if you're charged with a crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58, and your matter is continued to April 30th at 2 p.m. For hearing on any motions. Thank you.
Thank you. Okay. Thank you all.
Your Honor, I think we're all appreciative that you were able.
Waiting for the traffic so I can get out. Oh wow, fire truck. Yay. Peppa, thank you so much, Peppa. You're very, very thoughtful. It's very nice to know that there's people like you out there, sweetheart. Thank you, thank you, thank you, thank you, Peppa. So I guess I was mentioned. I don't know why. I didn't do nothing. You know. And here come the wonderful people from the courtroom. I know I got a viewer in there, right? At least I caught one viewer. Subscriber. They subscribe to my channel. Okay. Erica, the censor went good? Sense that it went good? Waste, much of a waste of a time as it can be, right? Yeah. Hello, Colleen. Peppa says she misses you. Yeah, true. Peppa says that she misses you and she can't wait. She can't wait to come and see you.
My house in New Hampshire.
She's wonderful, isn't she? Yeah. She is.
Got a mention today in there.
Yeah, I heard. Imagine that.
It's your moment.
Aiden's like being able to speak like First Amendment stuff, like his opinion. Colleen, they want you to say Clown Town.
Clown Town.
There you go.
I have my bind on the car.
Is it better or worse lately? Do you notice things getting better in Canton or worse in Canton? It's man, they don't. Why don't they leave you alone?
Stole my Queen called me poor.
I noticed that. It looked good. I thought it looked good. I thought it looked good. 100%. There's got to be a way we can change it legally to that. This petition. There's got to be a way.
response. I sent an email to the select board members, to Duty,
Yeah.
to DW, Tamara.
There's got to be a way because other people see. I know other people name the streets. It was pizza. Yes.
96%.
Yeah, I heard. Yeah, but we can maybe like go and vote on that, right? I think it's better. Queen Colleen Boulevard.
5% of the real estate. We don't own that one house.
Right. Well, that's
Why don't we change that front door to where it was originally? You know?
because that would no, you can't do that. It would be right then. No, it has to be wrong. It's Canton. Has to be wrong. Has to be wrong. Wow. Well, I hope Jeff's doing well. Good. You send out love for him. Tell him we said hi. So, just glad he ain't gonna deal with this stuff no more, right? Oh,
I was trying to fight turtle. After
oh yeah, I remember that guy. Uncle. They call him Gramps.
and he took it as a threat.
Oh my God.
Like, press charges on him.
And they spend all their time on the most nonsensical stuff and in the wrong time on legitimate stuff. It's just ridiculous. My town isn't that bad. I can't. Your town's that as bad as Canton is? Yeah. That's nope. Well, that too, right? You never know. All right. Thank you for coming. Thanks for supporting us. All right. So I have let's see if I can do this. You want to do this real quick? All right.
I'm gonna try to get my sign back on.
Yes. Service is horrible.
Must need like a wrist guard after like a whole week.
Yeah. It extends so I can put it like right in my belly and just hold it there, lean against it.
Burn after like 5 hours. I'm like, girl, don't fucking. I'm like,
Yeah, it does it's a long day when you're holding this stuff. So what do you think about inside? You went inside, right?
Yeah.
What did you think about it?
Nerve wracking, just because you never know. You think you got the law on your side, and
Right.
and then at the same time,
Just like that, they turn the script.
especially with Tim and Karen, And then when the officers kind of walk up the aisle slowly at the end, we're like, oh God, his bail's not getting revoked, is it? It's like nerve wracking, Like that shit. Like die.
You have a cannon?
Yeah.
Yeah.
But this is no, he has two.
All right.
Fancy cameras.
Yeah.
I don't even have so
Nice
fancy
lens,
cameras.
huh?
Yeah. I'll trade it. Little first aid, right? Little first aid. When you ever started talking about Jen McCabe's daughter's school, like, what the fuck are you doing?
Yeah.
Like, are you kidding
Somebody
me?
knowing these cats. Like, oh, the McAlberts are celebrating.
Oh, of course they are. Well, I didn't
Turtle
agree
Boy
to
can't
it.
go near him.
They didn't celebrate much.
But the whole point is they're trying to keep him out of court and it's not working for them.
Unfortunately, that precedent of that other case is there where he's allowed to come in.
Yeah.
I think it's pathetic. It took him that long. Oh, are you recording?
I'm live, but I don't know what I'm doing here. No, the whole thing's pathetic, Jess. You can, yeah, it's crazy.
Try to not stand in your way.
Yeah.
I don't want to be in your way. Sorry, but-
Guys, done for the day?
Still. Like, do you think we're gonna stop doing this? We need to in jail. Right, yeah. The laws in black and white, but I know I'm like you. I don't think one up. I know what I mean. I'm trying to like last year. No, look at the name. It's after the guy. He's Jack. I'm dying. And then you with the beers? Oh, yeah. No.
We're in the getaway.
Will, thanks for coming down and spending time with all of us at PF McCarthy's. It was an absolutely fabulous time. Everybody enjoyed themselves. Great to see Scott McGinnis. You know, but yeah, you and Nan are always welcome back. Always.
Really? I think she posted a picture of it a while ago, I think. Maybe that's yeah. You know what? Yeah, black it is. It's black. No, black chicken got it. Oh, it's no shit. Right on that. It's like, oh, yeah. Yeah, there's yeah. Pocket.
Yeah, wasn't Tully removed from the Norfolk County?
Yeah, why is
Bingo. I'm getting ready to ask that question.
Didn't
Yep.
he get sent to some state regional? So why is Tully even involved? Because Prince Albert calls Tully, but Tully technically doesn't work for fucking Meatball anymore.
All right. I'm not sure which camera you guys like better. The top camera is my phone.
The other day,
Bottom camera is a tablet.
it's not that it's
well, he's from New York, and obviously, Mark Federer's part of the team.
Well, I got them both in my hand. And what I usually do is I use the tablet to record,
No, if you're on.
and I use the top phone to stream. So you guys are getting the stream version, which is the mobile one. We can make the size of the screens different. That's easy. But again, whatever's best for you guys. If you guys think the tablet is clearer, I'll put my phone on mute and put the audio on the tablet.
Second day in a row, Mark Federer didn't say a word. He didn't even have to.
All right. All right. So we'll just leave it this way then, okay? Because the audio is coming out of the top, so you'll be able to hear it at least. Is there an echo? There shouldn't be.
Live. Texas to back up. That's what I was trying to do. Like bounce her up. Oh, that's all right. I'll find something. She's showing yesterday's hearing now. This one? Yeah, that's okay. That's the one. Okay. See when you search the channel like that? Yeah. She runs for her. Yeah. So I hate when creators do that shit. Yeah. Oh, you're live now. See if you Oh, yeah. So sometimes you have a glitch for like 20 seconds, and then when you check, you're not live anymore. But if you want to catch up to live, you just hit the live. That button, see up for it? Yeah. And then in the chat, see this? And then when you're in the live chat, yeah. How I kind of know what to do. Yeah.
How's the popular case? Anything, no movement on that?
Shown yesterday.
Lang?
I watched that on the way down here because Aiden posted it. It's a half hour.
Okay. Okay, so that path has started then, okay.
Well, yeah, so they already have the case. They're supposed to depose Martin.
I mean, sometimes I see Michael Dodson here now. Yeah, Michael Dodson, yeah.
I heard like.
Sometimes when you have 6, 7, 8, 10,000 people in the chat.
Yeah. I would do that. I fought Lang.
I mean, it's full of stuff.
How can Lang support the family, represent the family, and go to the freaking school committee that he hired you? How can that not be a massive conflict of interest?
He's related to the family.
You can't make this up. Yeah. Yeah, I remember when I was talking to Aiden that day. I mean, he's allowed to talk. You know? I don't think. Well, it's what he says. If they don't like, that's the problem. Oh, wow.
No, it's free. No, to be a member costs money. Yeah. But to simply subscribe to
what document dump? The document dump come from what AJ spoke in court. I don't know about that. I'd have to look into that. I don't know about the document. And who's this? Who's that? Tiny Woods and Law and Crime. Thank you for all you do in the fight for justice for all the citizens. I appreciate your diligence in this important issue. You know, it really is an important issue. It's a First Amendment issue. You should be allowed to say whatever you want.
Chat on their channel. Most people have that setting. Yep. But it's free.
Yeah. Oh, all right. I know.
But if you want a paid membership, and then they occasionally do like.
And again, we're blessed to have as much talent as we have. The people here that are supporting Aiden. I mean, look at this, right? Most of these people were here yesterday, and they're here again, right? Supporting Aiden, First Amendment. Up, make a hole. Yep. And here we are, right? Yep, we do. And think about it. We have all these legal people that do this for a living, right? They look at cases and they go over them and they go through them and they read the documents and the rulings and they make their own determination based on the law, right? You have Melanie Little and Brandy Churchwell and just outside people like Eve from New York, from Texas. I mean, there's a lot
I've been subscribed.
of people from all around the country and all around the world that not only support Karen and Aiden, but they support the First Amendment. And it's that important that all these people come out and visit us. Like Will flew in. Will stopped his life to come and visit us. Nan stopped her life to come and visit us. That's huge. These people are people that are maybe questioning this, saying, "Well, what's going on, right? What's going on? Let's go see what for ourselves." And they did for the. You can't see what you see here. It's Massachusetts, a little different. Yep. But again, it was really nice to spend some time with all you people on Monday at CF McCarthy's. We had a great time. Just so you guys all know, let me tell you the story behind that so you don't feel left out, because I absolutely wanted a bigger thing. However, it didn't work out that way. So here's what happened. I got Nan on the phone and I asked her, I said to her, whenever you come up, let me know and we'll bring you out, right? And wouldn't you know, she was a couple days later, I think she called and said, "Hey, I'm coming to Boston." I'm like, "All right, cool." And at that point, we were all psyched and happy, and it was thought that she let's get her together and meet some of the content creators, some of the people whose shows that she's been on, right? Like, let's get everyone together. So I invited everybody. Like everybody. I invited Aiden. I invited Will, Nan. I invited JFK and James. JFK was somewhere. He was out of town. So I invited James. I invited Mike from Young Jerks, Brian from LTL. Maz the Media showed up. Great to see Maz. Nurse Kim, invited her. Not, I don't want to say not the bigger content creators, but all the other smaller content creators. I invited all them so they can meet Nan and Will and have some food and hang out, so that when Nan or Will goes on that show, there's a face to a name, right? So I tried to bring everyone together.
I'm not only subscribed.
So I can say that I did that. That's what I did. I did. I tried to bring everyone together, all the content creators, to make it a better experience for all you guys. But next time she comes back, maybe we'll plan something a little bigger, right? At a bigger place. Now that we all know each other, and we'll see what we can do, right? One big fundraiser for Karen, right? Or for Aiden, you know? So, yeah. She really has, hasn't she? She's really jumped in with both feet. No doubt, no doubt. And the least we can do, right, is take her out for a nice meal of food and some nice people and get her to know and know these people. You know, that helps and that benefits everybody, right? Right?
So like when Sean.
Yeah. But you know, again, right? Like Will, he don't even live around here, right? He lives in Tennessee, and that boy got on an airplane and came down here to hang out with us. Nowhere else. He didn't go to California. He didn't go to Florida. Came to Boston. So, yeah, I got no sound because you turned the TV down or your phone down.
And the other thing will happen, you'll get involved in a chat. Yep.
Yeah, we'll figure something out. Maybe something bigger, a bigger venue. You know what I mean?
So you can go in
And we'll all come together, right? All of us, right? Baby steps.
Send them out into her chat. Yep. And 10 people will randomly win membership. Oh, really? But it's only good for a month. Yeah.
And you got to talk in chat for it to show for you to be able to get the membership.
Oh, yeah?
Yeah, because it randomly goes and picks
people?
It does, but you have to be in chat to pick from.
Yeah, yeah. Like right now, Melanie Little has 8,000 people in her chat.
Wow.
So if you got random, 10 memberships.
Yeah. So it automatically.
So say 2,000 of those people are already members.
Yeah.
You got 6,000 people that could potentially win.
Right.
Your 10.
Yeah, right.
You know what I mean? So it's totally random.
Yeah, right.
But on a small channel, you might only have a couple hundred people in chat.
Yeah, that's it.
And maybe half of them are already members.
Yeah.
So now you're down to 100 people. So, 1 in 10 is going to win your 10 free membership.
Right. Yep.
But once you have a membership, it'll expire after a month.
Yeah.
And then if you're constantly on that person's channel and in their chat.
No, negative. He's here. He's still inside. And everyone that's here on my chat, can you just do me a quick favor? Hit that like button and the subscribe button. It definitely helps out the channel. I do appreciate it much less. And if you want to catch some of this stuff and some members only stuff, then become a member.
Yeah.
Oh.
See, the way I look at it, it's a way that you're helping augment the creative channel.
Yeah.
You're basically paying them for it.
That's like StreamYard costs money.
Yeah.
Like then YouTube, if you remember YouTube, that costs money.
Yeah.
And the internet costs money. Your phone bill costs money. And just little stuff. That's one down shit. StreamYard, like $79 a month. And YouTube, I think
What do you got? You have membership.
Yeah, it's a medium. The next one up is like 10 freaking cameras going, and that's a bigger production stuff. But yeah, I mean, it all adds up.
I mean, what are you charging for memberships?
Oh, $1.99.
Yeah,
you have to.
That's reasonable.
You can't do 99 cents. They won't let you.
Oh, they won't. Oh, Sean McDonough was doing it in the beginning. Yeah, in the beginning.
I tried. It wouldn't let
they
me.
got rid of it. All right.
I don't know.
Yeah.
When I set mine up, I couldn't for whatever reason. So it's only $1.99.
Yeah.
And then like the next one's like $4.99. Like the next tier. So
see, I see some creators they have. Sean McDonough had 99.
Yeah.
I saw $1.99. Then I saw $2.99, $3.99, $4.99.
Yeah. See how like those increments? Like if YouTube will only let you do so much. You just can't go from 99 cents to $499.
Yeah.
You have to do something in the middle. But I'll look.
Maybe it depends on how big your channel is.
I haven't looked at that since maybe it is. I haven't looked
I
at
thought
that.
you had a choice of all of them.
I'll have to go back and look again.
Yeah.
And I haven't touched it or looked at it since I set it up, and that was months ago. Yeah, it adds up.
But I seen some channels that were brand new and they were already charging the $4.99.
The gifted memberships are the ones that are $4.99. So if I get gifted a membership, it's a $4.99 membership. Up, here we go.
You gotta kill a bee. How are you? Good. How you guys feel?
Mark, come on over here. Good. Sorry, Mark.
Mr. Carney, your attorney said what you did the other night was unwise. Do you agree?
Not going to comment on the merits of it.
We're here to,
Here's the distraction.
here's the key point. Not every encounter between people rises to the level of witness intimidation, even when sometimes people do get upset. This is a continuing issue in this state, uniquely to this state, that the statute gets used often for viewpoints and not against other people who are allegedly doing similar things. So we're not going to talk about the merits of this, but this is a very unique problem with the Massachusetts witness intimidation statute, that every time there is any encounter, that it goes into an arrest or a summons for witness intimidation. That's just not the case. And we'll see what happens in the future with that statute, because this is unique to Massachusetts.
How will the judge's order affect Mr. Carney's actions going forward? What will he not do that he might have been doing?
Well, there are orders that were issued by the court, and he'll comply with them.
Attorney Bredel, can I ask you a question?
Sure.
They mentioned Tully being the reporting police officer in this report.
Yep.
I thought he was not a part of this whole situation anymore. Is
Yeah.
that surprising that he was the officer listed?
Yeah, well, it's not surprising. Is it appropriate? I don't think so. The state police have a policy that every target of an investigation is entitled to a fair and unbiased investigation. I don't know how the very same state troopers who are implicated in all of Mr. Carney's reporting can appropriately give him a fair and unbiased investigation on anything, and why they continually crop up is unfortunate, and it's not gonna be unaddressed down the road.
Better, do you still expect to join the Karen Reed defense team? No comment on that right now.
Can I ask, in the judge's comments, the Commonwealth's comments rather,
Another win for the first one? I mean, yeah, sure. I mean, we're gonna beat this one way or another. Trial, motion to dismiss, however we have to do it. We're gonna, nothing I've done with illegal, so.
There was the question about whether this was defamation. What do you think about that?
Yeah, I mean, I haven't defamed anyone. I've been sued a million times before for libel. Won every single case. I understand how this works. You're allowed to have opinions. You're allowed to vocalize those opinions, even if people don't like them. So that's all I've done. And this whole thing, I've vocalized my opinions about the Karen Reed case and the witnesses involved in it. So.
Attorney Bredel, the Commonwealth was suggesting putting parameters on Aiden that dealt with defamation, like actually restricting what he could say.
Yeah.
You had an incredulous look on your face when the Commonwealth said that. What are your thoughts?
Yeah, I've never heard that one before. I think that's sounded to me like a product of the McAlberts wanting to operate the Commonwealth by remote control and get statements they don't like off their bat. But who knows? But I think that was totally beyond the pale, and not something that really has any part of a criminal prosecution. It's a prior restraint on speech. You mentioned the First Amendment. Once again, the Commonwealth, has nothing but scorn for the First Amendment in this county. I don't know what it is. I think they need a seminar, but, talking about this, that he wants to put on the Aiden Carney show. You're damn right he wants to put on the Aiden Carney show, and he has every right to. And, let's respect the First Amendment. I also didn't ask to be arrested. I'm not the one that asked for the show. I was just doing my job, and one day I was arrested and indicted. So any show was created by them. I'd like to point out that while we were doing this interview, somebody drove by and yelled, "He's guilty." I'm waiting for the Norfolk County District Attorney's Office to track that person down and charge them with witness intimidation, since I'm certainly a potential witness in my own case. But I'll hold my breath before that happens.
Feel, Aiden, that yet there's another charge that they're levying up against you. This seems to be a pattern. How are you getting up every day and dealing with kind of like the not only that, but the financial burden this is costing you to continue to come in and work through these cases or charges?
I'm getting used to it. Unfortunately, it's not surprising. What else is new? I guess Karen Reed could probably understand that better than anyone. So, but I'll tell you one thing, that the support of having all the people here. That I know that there's a lot of people behind me that are willing to support me through this. Whether that be showing up at court, donating, whatever that be, because it's not just me doing this. I'm in the front lines, but there's an army of people behind me that support this.
There was never any bail issued in this case, right? There was never any
Correct.
question
No.
of bail revocation.
Never stay away order, never a bail
Did the
order.
court conclude today by saying if there is another case that could lead to?
That's a standard warning that every defendant gets, that if there's a new crime, there's a potential that a bail could be revoked. That's a
And if there's a
statutory.
new crime, could Mr. Carney go to jail?
That applies to any litigant.
That's only bail is
There's a bail that's issued. Correct.
and there
Thanks,
still
guys.
is none in this case. The
Correct.
prosecution asked for 8,000, did not
Correct.
get it. So even if there is a fifth case, that would not lead to potential jailing.
I don't want to comment on, I don't want to speculate about the future, but, going forward, we're all adults here and Mr. Carney's agreed to things and we're going to comply with that. And we just want to get through this, get to trial where we can be heard. That's what we're looking forward to.
The other case where the similar restrictions with being able to come in and out of court and do his job, allow him to come in despite the fact that there's a stay away order. Has there been any issue with that order since that was put in place? Has there been any issues, any, examples of you breaking that order? Has it been effective? And
That order was thrown out on January 7th.
there
was
were
not
no
renewed.
issues during that time when you
No.
had it, you were able to come in and do your job? And
Right, yeah. Stopped showing up after that, so.
were you worried that if they didn't allow you to come in here, that it would affect your ability to do your job, earn a living?
Of course.
I mean, that's the heart of the First Amendment. He's covering a criminal case of high public interest. And whatever is alleged happening outside, his workplace is a courthouse. So he's got to be able to come in here. And that's what the First Amendment is about. These are public court cases. He covers public court cases. He's got to be able to come here.
The standard to intrude on that is astronomically high and should be and needs to be. And we're going to do everything we can to keep it there. Thanks, guys, for coming. Thank you. Thank you guys for coming. I appreciate it. Good job, Aiden. Oh, I shouldn't talk to you. I mean, oh my God.
You're on the record now.
I mean, Jesus.
You're on there. They watch you.
How can they assume that you tell me anything to do? That's just way off the pale. Way off
You
it.
ever think you'd be brought up in court like that?
No. Unbelievable.
Tom CPU's time to shine.
Sorry.
Get some new subs for that.
Yeah. Oh.
You got the exclusive. Oh yeah, for sure.
You like Melanie? Say hi to Melanie.
Out here, it's Cheech.
Yeah.
Get out here, watch the trial. We miss you.
Say hi to Will.
Oh, hey, Clara. You know me, Clara. Thank you for coming.
Isn't it awesome? Good luck, Aiden. Thank you.
Good job, Abe.
Nice job, sir. We're good. We're good. Yeah.
Oh, nice to see you. Thanks for coming. Appreciate it. Yeah, I'll be on YouTube. I'll be on YouTube tomorrow night.
Okay. All right. Well,
Good. Thanks for coming.
it wasn't terrible. Let's get through the day.
Jess was great. She was dynamite. All right. Let me say my little bye.
Big spiel.
How are you? Good to see you. Thank you.
Kind of went. Oh, just I was going to put over. We're just done.
Yeah. Yeah. Good job, Jess. Everyone's saying they love you.
Questions?
I'm Jess Machado. You can follow me at the Jess Machado Show. I'd appreciate your support. Thanks.
Twitter?
At Jess Machado Show.
There we go.
That's it.
We'll
Okay,
get you
bye.
going. Thank you, Jess. So yeah, everyone's got to subscribe to the Jess Show. She's great. She's got some awesome content. Please go subscribe to Jess.
Jess had the best questions out of any of the mainstream media.
She's better than the mainstream media in every way possible, you know?
Jessica's questions were better than the regular.
How does Tully still have something to do with this? How is that possible? I thought he was removed. Tully. I thought he was removed.
I don't know. It's not
It's
the state police policy.
Thank you. Dr.
You guys good, Mark?
Hi, Tim. Good job.
nice. Nice. Uh, wow. Pretty good. Alrighty. I remember that. I remember that interview I did with him. Well, we all made it. Yeah. All right, I gotta run. Bye, dear. You good? I talk to you.
I wasn't getting a sign on Tom's camera, but I was getting it on the mainstream media.
All of a sudden, they just see how they just sucked right in, and then Aiden would talk. They'd come back out, so they go back in.
I had the sign right behind him, but,
Yeah,
you were
perfect.
next to me, so it wasn't coming out on yours.
I know I couldn't see it.
But the mainstream media had the
Did they
sign.
catch it?
Oh yeah.
Nice. All right, bud. I'll see you.
All right.
I don't know. I'm sure we'll see you next week. Next week, right? I mean,
Get the next
17 and 18.
18, 17, 18. All right, bud. Careful driving home, Scotty. The 18th? All right, bye, dear.
It's the two. One's a Monday, one's a Tuesday. I'm assuming it's the Tuesday.
Okay. You have a good week, okay? I'll talk to you later. Thank you for coming. All right, so we got some really good people supporting Aiden and Karen today. Yeah. I'm not sure we can do much about that, but we all you guys and all you girls, you all became famous today. You all became famous. They mentioned us in court. Imagine that. No court tomorrow. I'm being told it's the 17th and the 18th for court. Whatever it is, we'll definitely get that going. And we tried something different today with the tablet. So I'm not sure if you guys liked the tablet deal today with a little bit better picture, I think, for you guys. So, do you guys have any questions for us? Oh, sorry about that. Hold on. All right. Do you guys have... Yep, we'll do a show in the morning, and we'll go over the First Amendment stuff that they were referring today, and go from there. I'm glad it worked out the way it did, but again, oh, what's this? Your heart, your courage, and gratitude. You're a real one. The world is much better for you in it. Thank you for the freaking awesome comments. And I know Mike would enjoy to see that. Gail, it's my pleasure. Thank you for being on the other end of it. You know, by you being on the other end of this makes it all the worthwhile. Really. So Gail, I thank you very much personally. You're a great asset to what we do here. As is everybody, right? So, all right. Please hit the like and subscribe button on your way out. Please. Karen does not have court tomorrow. No court tomorrow for Karen, but we will be live. And I hope everyone has a wonderful day. It's Thursday. Yeah. Pizza is on Sunday. I think the standout Sunday in Plymouth. I'll definitely let you guys know about that tomorrow. But with that said, Plymouth is a go. If you're not doing anything, you live in the Plymouth area, come on down, bring a sign. We go do Dunkin's later, buddy. We'll go to Dunkin's later. Bring your sign, bring an appetite, and we'll go and get some pizza after. Yeah, I know I'm not scheduled, but I know that I'm going to Plymouth standout Sunday. So I'm thinking pizza at that point. But that's just throwing it out there. Just save some money, and tomorrow we'll have a better handle on things. So with that said, I hope you all an absolutely wonderful freaking day. And I can't thank you all for being here. Born Saturday, that's right. Okay. Either that. We'll see you guys in the morning and we'll figure stuff out today and fill you in tomorrow. Thank you for being here, everybody. And again, thank you for the like, subscribe, and please thank the mods. The mods are the reason that this happens. No mods, no show. So again, the mods are hands down the best. So all you guys, please enjoy yourselves. Be safe. And I love you all, and we'll see you tomorrow. See you tomorrow morning. Thank you all.